Hello and welcome to my screencast. I'm Joy Poe. This is for entrepreneurial growth. Today I'm going to talk about intellectual property and cover trademarks and copyrights. First, we're going to start with your brand and how to protect your brand through trademarks and copyrights. We'll begin with Susan Gonelius's article called What is a Brand? And she states that a brand has 5 points that come together to define the brand. The first would be the brand promise, which is a combination of the quality of the product and the feeling the product brings the consumer when they purchase and use the product. The brand perception, in a nutshell, is the way the consumers perceive the brand despite the company's presentation of the product. The brand expectation is referring to the consumer's assumption that the money they spend on your product lives up to the quality and other expectations that they have of your brand. The brand persona is the personality. Who is your brand? From appearance to personality and everything in between, your brand persona is one that the consumers will evaluate and judge before they do business with you. And finally, the brand elements all together, combined with your logo, messaging, packaging, and other elements of branding, work together to promote the product in the best way for optimal growth. Trademarks versus copyrights. A lot of people have confusion about these things. Trademarks, copyrights, and patents protect different kinds of intellectual property. The U.S. Patent and Trademark Office defines the terms as such. A trademark is generally a word, phrase, symbol, or design, or combination thereof that identifies and distinguishes the source of the goods from one party to those of others. Underneath that umbrella is also a service mark. It's the same as a trademark, except that it identifies and distinguishes the source of a service rather than goods. On the other end is copyright. A copyright protects original works of authorship, including literary, dramatic, musical, and artistic works such as poetry, novels, music, songs, computer software, architecture. The duration of copyright protection depends on several factors. For works created by an individual, protection lasts for the life of the author, plus 70 years. For works created anonymously, pseudonymously, and for hire, protection lasts 95 years from the date of publication, or 120 years from the date of creation, whichever is shorter. And finally, I'm going to add in patents because we are not covering them, but is often confused as well. So a patent is a limited duration property right relating to invention granted by the United States Patent and Trademark Office. These patentable items are things such as materials, manufactured articles, industrial processes, and chemical compositions. So now that we know the difference between copyrights, trademarks, and patents, let's talk about copyright facts. A copyright protects original works, both published and unpublished. The Copyright Act of 1976 allows the owner the rights to disseminate the work in any manner they choose, and it is illegal for anyone to violate those rights. If an owner's rights are infringed, a court will provide the remedy to the issue. However, copyrights are secured when the work is created and fixed as a copy, so work does not need to be copyrighted to claim the copyright. But your work must be legally registered with the Copyright Office in order to be able to file copyright infringement claims. Copyrights are highly recommended by the USPTO for a variety of legal reasons. Duration of the copyright depends on a variety of details outlined in the application, and copyright protection through the USPTO does not protect your work outside of the United States. The other thing that often confuses people is public domain and Creative Commons. We often find materials outside of the copyright regulations. These materials fall under public domain or Creative Commons. These notations allow usage for materials without the need for copyright permission from the artist. Materials fall under the public domain in 4 ways. The copyright has either expired, the owner did not renew, or the owner dedicates it to the public domain, or finally, copyright law does not protect that kind of work. Creative Commons allows the creators to free their work of copyright laws internationally and ensure the work is free for everyone, everywhere. You must be the author of the materials to donate it to the Creative Commons. The images to the left are available under the public domain or PDM. All of the other images in this presentation are available under the Creative Commons or CC0. Neither designation requires citation, although reference to the sources of the material is always appreciated if you have those references and sources. Remember, a work is copyrighted when it's created and copied, but you cannot sue for copyright infringement unless the work is registered as copyrighted. The copyright symbol is proof that your work is legally registered. So visual art, copyrighted when you first create it, published, printed, same for poems, same for photographs. Trademark facts. A trademark is not an umbrella that covers domain names or business names. Domain names are registered with a domain name registrar. A business name is not necessarily a trademark, but it sometimes can be. Some states, including North Carolina, require business owners to register their business name with the state or local jurisdiction. This is called doing business as or registering for a DBA. A trademark is registered through the United States Patent and Trademark Office. Selecting a unique mark is the first step in registering your trademark. Not every mark is legally protectable, and not every mark is registerable with the USPTO, which means you must consider if your mark is unique enough to be registerable and your mark is strong enough to be legally protected. You, as the trademark owner, are solely responsible for the enforcement of your mark. The USPTO states the most common reason for a trademark application to be rejected is the likelihood of confusion between the mark of the applicant and one that's already been registered. It is the responsibility of the applicant to perform a trademark search to ensure the mark will not have that likelihood of confusion. It's made up of two parts. Your mark must not be similar to any other registered mark that looks, sounds, or means something similar. Neither can your mark have a similar design element or a similar general meaning. In addition, your mark must not have a related goods or service similar to the trademark, another trademark. If your mark has only one of these conflicts, your application could still be accepted, but if your mark has both of these conflicts, your application is likely to be rejected. In addition to selecting a mark that's not easily confused with another trademark, your mark must also have a trademark strength. This is yet another rather ambiguous requirement. A strong and unique mark will prevent future applicants from having conflicts with your registered trademark. A complete trademark search can identify any problems with your mark and prevent you from a rejection from the USPTO. The government site offers the Trademark Electronic Search System online and offers a wide variety of help topics in conducting that search. The search process is extremely complex, and the USPTO highly recommends hiring a trademark attorney to help assist you in your search. The USPTO's database of trademarks does not include marks of parties who have common law rights to their mark. Common law rights may be stronger than your applicant's mark due to their length in business. So common law rights are, it's a trademark that is unregistered that starts when a business begins using a mark in commerce for the first time within a geographical region. It endures with continual, deliberate use and is shown by the superscript TM. A business is not required to register a trademark, so common law trademark can stop a competing business from using similar marks that can confuse consumers in your area. Common law trademark rights are limited to a geographic area. The intellectual property is used in any areas where it could reasonably expand. Therefore, it's really just kind of a regional geographic trademark right. Trademark attorneys, according to Wikipedia, in the U.S., trademark attorneys are attorneys at law who specialize in trademark matters. Trademark attorneys may be in a subdivision of a larger firm that deals in intellectual property or may have a discrete firm dedicated entirely to trademarks. If a corporation frequently has need for a trademark attorney, the business will employ a full-time trademark attorney. The benefits of a trademark attorney are that while the USPTO will help an applicant move through the application process, once you hire a lawyer, the office will only speak with your attorney about your application, kind of washes your hands of that complicated process. Hiring a trademark attorney will ensure a thorough trademark search, a more favorable application, and aiding the enforcement of your trademark once it's secured. You can see how hiring an attorney, while not required, may save you from costly future legal problems, including the issue of common law trademarks and trademark infringements. The USPTO cannot provide you with legal advice, therefore you may consult an attorney referral service, the internet, or the state or local bar association in order to find a trademark attorney. Finally, we have resources for copyrights and trademarks. You can begin your search for accurate information at the USPTO. You can find out information about copyrights at the copyright.gov. Information on how to proceed with infringement problems. You can go to stopfakes.gov or the nolo.com legal encyclopedia. How to conduct a trademark search can easily be done at the USPTO. This is the link here. Trademark attorney search, again, USPTO has a fairly good practitioner search. And then for information about public domain Creative Commons, we have the creativecommons.org, publicdomainarchive.com, and fair use. And for information about copywriting music, you can look up ascap.com. I hope this has been informational for you and that you've enjoyed what you've seen. Thanks for listening.